like to welcome you all. This is the second of our updates on recent energy case law from the Court of Justice. And we also have with us Dr. Adrien de Hauteclocque, who, as I hope many of you know who listen in to these updates, will recall that he and I do this together on each occasion. So Adrien, who is head of cabinet at the General Court, is obviously very well placed to give us a peep into not only what the court has decided, but he will, at the end of this webinar, take us through some of the pending cases. So perhaps, Adrien, you would like to kick off, and then when you're ready, give me a sign and I'll take over. Thank you.
Sure. Thank you very much, Leigh. Good afternoon, everyone. I'm very happy to be here with you on this regular meeting. Now we've been doing this for some times, and it's always a pleasure to be able to give a word indeed on what has been said recently. So this time is since last June, I believe, and on some of the pending cases. But we have a lot of pending cases, so I'll focus on just a few. So I think I'm sharing my screen properly, hopefully. So let's start. So I want to start with with three cases. First, I want to address where we stand on the Aquin Saga. So we've been discussing these cases for some time, so they are moving on. We are getting closer and closer to the end, but it's still some road to go. So Aquin is a project for an interconnector between France and the UK. There were two issues. One was the inscription on the PCI list. So that's one stream of cases, because he was in the PCI list, then he was removed. And the second was the decisions of ACER. So after the regulator could not agree on whether or not it could work as a merchant interconnector, so being exempted from some of the obligations. So of course the promoters went to see both national regulators. Both regulators could not agree, and then after 6 months he went to ACER. ACER decided that Aquin could not get the merchant status, and this decision was confirmed by the Board of Appeal, and so Aquin appealed the decision of the board. I think there was two interesting issues on that case. First question, and the main question, was the nature of the control of the Board of Appeal exercised on the decision of the agency, and the other was the articulation between the PCI mechanism and the merchant mechanism. So the General Court accepted the appeal on the basis that the Board of Appeal would have exercised only a limited review of the agency decision. And so that was, I think, very interesting, because it raises the question of the articulation between what the agency is doing, what the board is doing, what the General Court is doing, and in the end, even what the Court of Justice on Appeal is doing. So it's the articulation of all these levels of control. And so the Board of Appeal explicitly said that it was doing only limited review, and a review of the sort of the one exercised by the General Court for different reasons, in particular because the time that was allowed for ruling on the appeal was very short, that they wouldn't have the resources. So a few arguments like that. So to say, so we are doing the same sort of review than the General Court is doing. And so the General Court said that it was not possible, because itself on such complicated appreciations, it was himself doing a limited review, and so limited review over limited review was a problem. And so the General Court granted the appeal. So now we are at the level of the Court of Justice. We got the opinion of the Advocate General, and the Advocate General sided with the vision of the General Court. So now we are waiting for the final decision of the Court of Justice on that issue. But I think that's also interesting because we have to see it probably in a wider context of the evolution of the architecture at the quasi-judicial and at the judicial level in the European Union. You might know that in the IP field, there's always now there's a filter mechanism between the Court of Justice, between the General Court and the Court of Justice. So you don't get an automatic right to appeal to the Court of Justice. And that filter mechanism that is working in practice in only a few cases gets now to the Court of Justice in that field. That filter mechanism might be expanded to other sorts of decisions, and actually maybe all decisions taken by boards of appeals, because we have boards of appeals in many different sectors, in the banking sector, in other sectors. So that's a very interesting, I think, development to follow. So there was also a case introduced already against the decision taken by the Board of Appeal after the decision of the General Court. So on that stream of cases concerning the decision concerning the merchant, the decision of ACER concerning whether or not this can go unregulated. So we have two cases pending, one at the Court of Justice on appeal from the General Court, and another one at the General Court. So on the second stream of cases, which is the inscription of Aquin as a PCI, there was two appeals again. So one is still pending at the General Court. So the other one was dismissed as inadmissible, and the Court of Justice confirmed the dismissal. So this one we are also getting a bit closer to the end. So now I'll move to a case of September this year, early September, Benetza ACER. I think this one was also actually very interesting. It concerned the decision taken by ACER once again when the NRAs, the national regulators, could not agree entirely. This time the issue was on the common coordinated capacity calculation methodology for Western Europe. And so the national regulators, they could agree on most things, but not on everything. And so as they could not agree on everything, at some point, and after always this 6 months period, it had to be referred back to ACER. And so ACER took a decision. But what was interesting is that it took not only a decision on the points of disagreement, but on the whole methodology. And so the point was ACER competent to take that decision on the whole of it, on the whole regulatory object, let's say, or not. And that's why there was an appeal by Benetza. There was also an appeal by Germany, and this appeal is still pending because it was suspended waiting for the decision on that appeal by the German regulator. And so there on the ACER, so the General Court sided with ACER on that one and decided that the competence of the agency was not completely limited to the questions or the aspects where the NRAs were disagreeing, because you need to give ACER sufficient competence to fulfill its mission. That was really the broader context. So there was an internal market rationale behind all of this. The General Court said that the balance of power is ensured also between the balance of power between the national regulators and ACER is also respected because the board of regulators has to give a favorable opinion, which it did this time under Article 24 of the ACER regulation. So that plays a role. I think it was also pragmatic in a way because these are very complex regulatory objects, and so if you move one bit, then the other one can be affected and everything. So that's hard just to focus on where the disagreement was, even. And actually, it seems it was also not completely clear the scope of the disagreement. So as there is a need for coherence, of course, it was difficult probably to rule differently. Of course, the subsidiarity argument was raised, maybe a bit surprisingly for some, and so the General Court said that no, actually, this mechanism of referral to ACER is the expression of the principle of subsidiarity. So the national regulators go first. It's only when they disagree that ACER has to rule. So on the competence, no, we know ACER is when there's a referral on some aspects, actually can rule on the whole of it. So, however, that was not the end of the story, and the General Court annulled the decision of the Board of Appeal on an issue of applicable law. So I think it's fairly ad hoc in a way. It can even come as a surprise. There was in a way a bit peculiar thing in that case is that the substantive law changed between the decision of the agency and the date and the adoption of the decision of the Board of Appeal. And so the question was whether the Board of Appeal had to apply the law as it stood when the agency delivered its decision, or if it had to apply the law as it was applicable when he was ruling himself. And so the General Court has also, it's interesting to see that Venezia was making arguments based on the forthcoming electricity regulation, especially Article 14 and 16. So there was no doubt that he would be coming very soon and that he would change probably the outcome of the disputes. And so the General Court decided that in a way the position of the agency is not fixed before there's the decision of the Board of Appeal, and so the Board of Appeal had to apply the new law. And so as there was an error in applicable law, then the General Court decided to annul the decision. So I think this one fairly interesting. Last one on my side is not an energy case, but I think it's interesting for all energy aficionados because it's about the articulation between the powers of national regulators and the role of national courts when they have to rule on something based, in that case, on Article 102, so abuses of dominance, and related national provisions. So we are in the railway transport sector. It concerns DB Station, so Deutsche Bahn, so we are in Germany, which is the railway operator. And so DB Station decided to change its prices list, and so it resulted in an increase of infrastructure charges for some of the users. And so, of course, they were unhappy, and so they went both before the national regulators, who has an exclusive competence to rule on tariffs, and they went before national courts with a claim for reimbursement of these charges based on the abuses of dominance provisions, national and EU. So what's the articulation between the two? Actually, the national regulators sided with the user and so asked for a change back to DB station. So what's the articulation between the two? So I think in a very articulated judgment, so the court said that the national courts retain competence to apply the abuses of dominance provisions, even though the national regulators have an exclusive competence on tariffs. However, the undertaking, so the user in this case, had to go first to the national regulators to get a decision. And then the national court has to take into account that decision, due account of it, but of course is not bound by it. And the national court does not have to wait for potential appeals. This is, of course, to ensure the, let's say, full effect of the abuses of dominance provisions. So I think a fairly balanced judgment and interesting. I think, Leigh, at this stage, for me, I'm done, I think. Yeah. Yep, I stop sharing. And maybe I mute, and you should unmute.
Thank you. Okay, so I think here's mine. Okay, so thank you very much, Adrien, for an excellent review of some really important cases. So let me go immediately to, I think, a very groundbreaking case, the case of Nord Stream 2. I think a pipeline that is a kind of a household name now. And this case concerned a challenge brought by an individual company, Nord Stream 2, to an amendment to a directive, the gas directive of 2009. And the applicant argued that that amendment had been carried out with the sole purpose of imposing regulation such as third-party access and unbundling on Nord Stream 2. So they took the rather unusual step of challenging a directive. That's unusual because it's very difficult normally to convince the European courts that in what we call a direct action by a non-privileged applicant, so a non-privileged applicant being the party to whom the measure is not addressed, but who claims that they're affected by it. So it's very difficult for a general measure, such as a directive, to have to meet the Plowman test. So they have to show they're directly and individually concerned. And that Plowman test is a very old case, going back to the early 60s, and it actually concerned the importation of clementines. And this led the Advocate General, Bobek, in this case, when he reviewed the General Court's judgment, which had found that NS2 had no standing. They were not, therefore, able to mount a substantive challenge to the directive. He said, well, we have to look here at the very different interests that are concerned. A pipeline here is certainly not the same as a clementine. So he advised the court that NS2 was indeed individually concerned by this directive as well as directly effective. And the court, the Grand Chamber, followed the Advocate General in this case. So I believe this is the first case where a directive could be struck down. At least the admissibility tests were met. So what the court found was, we, of course, as we know in European law, we never look at the label. We never just look at the form. We look at the effect. And the effect here was clearly targeted at an individual's legal situation. So in this case, NS2. Now, one of the big problems, of course, is that directives have to be implemented at national level. So it's quite difficult usually for an individual to say, well, that directive concerns me directly. It's in fact usually what we argue is it's the implementing measure that will directly affect the company, and therefore the proper route to challenge the directive is first to challenge the implementing national measure. And if there's some problem with the underlying directive, then when you refer a question to the courts in Luxembourg, you can raise the legality of the directive. But what was interesting in this case was that the court held, well, in fact, the member states have very little discretion, if any, given the very wording of the directive, to come with a result that would be different from what Nord Stream 2 claimed, which is that they were being denied a derogation or the possibility to ask for a derogation from these rules, and they couldn't apply for an exemption. And indeed, the way the directive had been drafted was to make sure that that was what would happen. So member states then at national level could not vary that outcome. So not only was Nord Stream 2 directly concerned, but they were individually concerned because they were the only parties, in fact, who would be in the situation that they could not claim a derogation because the pipeline at that stage had not been completed. And the directive, the amended directive, required that in order to qualify for a derogation, the pipeline had to be completed before the directive entered into force, nor could NS2 apply for an exemption because exemptions only applied at the so-called pre-investment stage, which was well past in this case. So NS2 then fell into this category of not being able to ask for a derogation like other pipelines, the older pipelines coming into Europe. They all were actually given derogations, and it couldn't ask for an exemption. So therefore, it had to apply the full rules on unbundling, on third-party access, on regulated tariffs as required under the gas directive. So that's an important case. Before I move on to the next case, state aids, of course, what's happened there is that the Court of Justice referred the case back to the General Courts. The General Court will have to take a new decision. Now, one could ask whether or not there will be any interest to continue the case, given, first of all, Nord Stream 2 was already bankrupt, I think, last summer when that judgment was handed down. And of course, since that time, it has been rendered inoperative. So it will be interesting to see whether, in fact, that case will be continued. So moving on to state aids. We always have a lot of state aid cases in this review. They continue to dominate at both the level of the General Court and at the level of the Court of Justice. We have a very interesting case from the Netherlands. And in the Netherlands, the government decided to close down a number of coal-fired generating plants at the time. They have, of course, since been reopened, but in late 2019, the government had decided on early closure. But they had also adopted legislation in which compensation would be provided to the owners of those plants. This was not then notified as a state aid to the Commission because the Dutch government took the view that the measure was of general application, was based on general legal compensation rules, and therefore this wasn't a state aid, it wasn't selective. However, the Commission began proceedings, but it rapidly, or quite rapidly, closed those proceedings on the basis of its findings after a preliminary investigation. So the first part of the state aid rule procedures, that, well, they didn't really have to take a decision as to whether these compensation measures were aid or not, because in any event, the aid could be deemed compatible. Now, the Netherlands challenged that decision on the grounds that this adversely affected its own legal situation, as well as that of the recipients of the compensation. And the Commission argued that it didn't have to open the full procedure, and that it would be it would only do that had it had serious doubts as to the compatibility of the aid. Here it didn't. But what the Netherlands was arguing was that if you have doubts about the meaning of the measure as aid or not, the qualification of the measure as aid or not, you must first determine that it is aid. And if you have difficulties in doing that, you must open the formal investigation. And the Commission said, well, you know, that takes a lot of time, and it's much more efficient if we just do it this way. So we sort of leave the definition issue in the middle, and we kind of quickly wrap up on the compatibility test. So that was the Commission's sort of line of defense. However, the General Court disagreed, and it goes back to the very language of the treaty and says, well, you must first decide whether the measure is aid or not before you can then go on and assess compatibility. And indeed, the court also affirmed that this approach of the Commission's would have negative effects on both the member state and the recipient of the compensation, because if the measure was qualified as aid without a proper examination, then of course there would be lots of problems going forward. If the compensation was varied, there could be penalties for failure to notify. There could be impact on accumulation with other different aid schemes. So this was not a good solution. So that decision was quashed. Moving on to the Irish Wind Farmers Association, another state aid case, and one we have looked at before when it was at the General Court. Now it gets, of course, to the Court of Justice, and that case involved a taxation measure, which the Irish wind farmers claimed was very beneficial in the way it was calculated for fossil fuel producers, whereas the actual so-called receipt and expenditure method that was applied was very unfavorable to wind. And therefore, they argued these fossil fuel generators were getting a selective advantage. This was dismissed by the Commission. The Commission closed that case after a preliminary investigation. And the Irish Wind Association, the Irish Wind Farmers Association, appealed to the General Court. The General Court held, on the basis of case law that had just been handed down by the General Court, the Tempest case, which we've also discussed in previous reviews, that the Commission was not bound to open a formal investigation procedure if it was convinced there were no serious difficulties in reaching the conclusion that the measure was either no aid or it was compatible aid. So that judgment then reestablishes the Tempest Line of case law, which is very important, increasingly important in these renewable energy cases, because you see a lot of challenges being brought, but the Commission confining itself to the preliminary examination phase. And again, the court reminds us that the Commission is, of course, under a duty to obtain all the requisite information and opinions to make sure that it is acting independently and can reach an objective viewpoint as to whether or not it should open the formal phase. But as we have seen in previous cases, it's very difficult for third parties to know what the Commission has at its disposal, because, of course, in the preliminary investigation phase, third parties are not admitted to the procedures in any way. And so it's a bit of sort of groping in the dark to realize what the Commission knows and what it doesn't know. But this is an issue that comes back again in the case law. So it's important that the Commission then is not just able to only look at what the member states give it, either in pre-notification or in the preliminary phase. It's important that the Commission does take a proactive approach and look to see what information could have been available. But it's, again, very difficult for third parties to really challenge this effectively, because you don't know what the Commission has looked at or not. Again, the court recalls that the length of the procedure is no guidance as to whether or not the Commission does have serious difficulties in reaching its decision. So this case lasted more than 3 years. And the wind farmers' argument, well, that shows you in and of itself that the Commission had difficulties, was rejected. So the fact that there's a long period of investigation, and also that the aid measure is complex in and of itself, does not mean that the Commission should in any event open the formal investigation procedure. And the reason the court says is that they need a long period. If it's more complex, they need that longer period to discuss matters with the member states during the preliminary procedure. So that finding really reinforces the idea that the preliminary phase in a state aid procedure is very much about a dialogue between the member states and the Commission, and the position of third parties, whether it's competitors or the beneficiaries, is very weak there. And we see that coming up again in the next case. And this is again a state aid case. And again, it recalls the Tempest line of reasoning, but this has an interesting twist to it. This is about capacity remuneration mechanisms. It's about the Italian system of capacity remuneration mechanisms. And there have been several appeals to a decision that the Commission took in 2019, which was actually a follow-on decision from its first decision on the Italian system in 2018. And in 2018, the Commission had looked fairly in depth at the scheme, but the scheme was then changed. And in the meantime, the clean energy package had entered into force, including the new electricity regulation, which actually contains a separate chapter, a new chapter, on rules for calculating when such mechanisms were required, and various limits as to the types of plants that could qualify, especially if they were CO2 emitters. And there had to be a resource adequacy plan and a resource adequacy assessment carried out by ACER, etc. So the landscape, the regulatory landscape, had changed quite considerably in between the time that the 2018 decision was adopted and the 2019 decision was adopted by the Commission. But again, despite the complaints of two parties, the Commission refused to open the formal investigation. And interestingly here, the complainants said, well, this investigation is much too short. You couldn't have, in this period of time, really gone into the details of this case. So that shows you that you didn't even investigate properly, and you couldn't have established whether you had serious doubts or not if you had really just brushed aside all these new developments. However, that argument too was rejected by the General Court, and the General Court held that the Commission had exercised its discretion properly. So a very interesting case for those of us following capacity remuneration mechanisms. Now to get to a very important case, which was handed down on Wednesday, just in time for us to talk about it. Very kind of the court to cooperate. And that is Austria versus the Commission. And this is a kind of a follow-up case to the very famous Hinkley Point case, which also concerned nuclear power. And this is a really interesting case because it concerns a lot of rather complex and unusual legal issues. In this case, Hungary entered into various deals with Russian backers to obtain funding for 2 new nuclear reactors called PAX-2. So, of course, there's a PAX-1, an old nuclear plant, also based on Russian technology, and PAX-2 would be then new Russian plant based on new Russian technology. So the Russian government had promised to give 2 nuclear reactors free of charge to Hungary, but then they would finance the installation and the startup with a loan of 10 billion granted then from Russia to Hungary. Of course, this raises some interesting questions about the definition of state aid, because this is money coming from a non-member state. But however, that would be, I believe, combined with Hungarian money, so it did then fall within the definition. The task of developing this project was given to a company called a JSC NAEP. So this was, in fact, a Russian company that was appointed to build these to build these reactors. And there was therefore a concern that the procurement rules had not been properly applied because the selection procedure of this particular entity had not been made in full accordance with the procurement rules. So this is a very interesting case because it raises the issues of the interaction of procurement law with state aid law, something that a great deal has been written about, of course, over the years. And it's interesting because it follows in the wake of the Hinkley case, where the Grand Chamber had said you cannot declare state aid to be compatible if that would amount to a breach of another principle of European law, treaty provision, or of secondary legislation. And Hungary, of course, went ahead and commissioned the building of the plant. And the Austrians then complained that the procurement procedures should have been properly applied, and that a complaint concerning the failure to carry out those procedures should have been taken into consideration when the Commission had approved this state aid. So the General Court, however, rejected the plea about the lack of compliance with the procurement rules. And interestingly, it clarifies a provision or clarifies a statement in the Hinkley case as to whether or not the breach of another rule of European law has to be indissociable from the state aid measure or the state aid that is under consideration. And the court in Hinkley had not made that qualification. And so there was quite a bit of writing following Hinkley speculating about whether or not that test still applied. But the General Court here says, yes, it does apply. And so you cannot make the legality, the compatibility of a state aid contingent on a procurement procedure. So that would then raise problems in terms of procedural rules, because you have different procedures for different types of legal control. Procurement has a procedure, state aid has a procedure, and this would bring problems with the principle of autonomy of administrative procedures and remedies. Also the role that we just saw between national courts and European courts and regulatory authorities in the DB case. So we have to bear these sorts of considerations in mind. So this appeal was rejected. And I mean, there is more to the PAX2 case, but it's really, I think, a very significant case on this finding about the indissociable link between a breach of another area of European law. Now, probably Austria will appeal. Let's see, and give the general, the Court of Justice the last word. But another important aspect of the case is that Austria had claimed that the huge amounts of aid going to the nuclear sector would result in unequal treatment and exclusion of smaller producers, certainly producers of renewable energy. And therefore, that in itself should have made the aid illegal. But the court recalls the famous Article 194, paragraph 2, that member states are free to determine their own energy mix. So that was also rejected. Very quickly then, to round up, before we hand back over to Adrien and maybe hopefully take questions, we've got some very interesting opinions by Advocate Generals, Advocate General Rantos in this case, and in another pending case. Again, renewable energy, and again, going back to the very definition of state aid is often the case. And this is an interesting case, a Latvian case, where a national measure required then the TSOs to pay twice as much for hydroelectric energy as they did for any other form of energy. And the question was whether or not that was a form of state aid. The scheme had been attacked and found to be illegal in the past, and so the state paid for compensation to the producers who had to repay the illegal aid. So that was also a feature of this case, as well as the application of the compatibility criteria. So this is an interesting case because it actually brings into it brings into the picture an important problem that has arisen from the famous German renewables case as to how to define state resources when they are not coming directly from the state budget, but they're being levied on consumers. And there is a lot of discussion about the tests that have evolved in the jurisprudence, and whether or not in particular the question of control over state resources, how important is that following that German case. And there was some argument, and we have another big case pending before the Court of Justice on German network charges, where the argument is made that you have to show, first of all, that you're talking about a compulsory levy that is imposed by law on consumers, and secondly, that there has to be those levies have to be permanently under the control of the state, and that there can be, there's no discretion as to how that can be used. And the way that these tests were formulated in the earlier German case on the German renewable levies raised a lot of doubt as to whether or not these were alternative tests or cumulative tests. And the Advocate General is saying here, nope, the answer is no, they're alternatives. And he goes back and looks at the case law and to substantiate his findings. So this is an important case. And finally, there's a very interesting case again about incentive effect for these renewable projects. This is Estonia. And Estonia, you often seem to come across projects that have long started and then they get aid, and then somebody says, well, wait a minute, you're only supposed to get state aid to change your behavior. So if you've already done something, you're not going to qualify. And this again is one of these cases where it's claimed, well, the project had already started. There was complaints about it, had to be redefined and reorganized. And then more aid was given to compensate for the inconvenience of changing the rules, if you like. And it was again argued, well, wait a minute, you'd already started as a producer of res, so you didn't need this additional aid. But what the Advocate General says here is, well, you have an incentive effect because you have the incentive to stay in business. If the aid is withdrawn now, then you would close down. So there's still, even although you started before the first batch of aid was given, you have an incentive to stay in the market, and that is an incentive provided by a second batch of aid, because otherwise you would exit the market. So that's also a rather interesting case defining then the scope of incentive effect. So thank you very much. Then I think that's my caseload. And I turn my screen back to Adrien.
Thank you very much, Leigh. It's always very interesting to see all these stated cases. It's true that for a long time now, a majority of the cases we have are stated cases, and still a lot of issues. And it's true that when you read the Hungarian case, really interesting, but still a lot of things. I mean, you can discuss. I mean, the notion of the indispensable link. Well, it's
Indissociable link. Yeah.
indissociable. No, but that's I mean, that's really interesting case, and we'll have more cases. So you've talked about these 2 or 3 opinions. So we'll next time hopefully discuss the judgments. But we see in the pipe not that many for once stated cases, as you're going to see now. I'm going to try to share the screen. Up. So there are many. I think we're good. So there are still many stated cases, but a bit less, it seems to me. So we will see if this slowdown continues. So I think one of the new star, of course, is the. I think I'm sharing. Yeah, the new star is all the cases concerning ACER. And this is really interesting for us. Of course, it's an issue to have that many of these cases who are, of course, very technical. I mentioned at the beginning the Aquin Saga. So we still have 2 pending cases. One from Germany, I also talked about it very quickly, is the follow-up from the Venezia ACER case I discussed a bit earlier, where there was an annulment for an error in the applicable law. So we have more coming up for sure. One concerns the ACER decision of I think end 2019, I guess, on capacity booking platform. This is only one appeal. There's a big pack of appeal concerning the coordinating operational security analysis and the methodology. There we have the French regulator, we have Venezia again. So this one is a big one. So we are the written procedure I think is finished. So we're not there yet, of course, but this is progressing. But I think yeah, we'll be discussing more and more, I mean, these cases in the new in the next episode of our case law update. One of the new thing will be, but this is really too early to talk about it, is all the cases concerning the delegated regulation adopted by the Commission on the inclusion of nuclear and gas in the taxonomy. So we were expecting these appeals. They finally came in. There are a few from different groups, a few from NGOs, one from, and this is interesting, maybe unexpected even, one from a European member of parliament, as an individual member of parliament, so not an appeal from the parliament. And we have, of course, the appeal from Austria. So they are not, I think, even the plea is not even published in the official journal. So I'll refrain to, of course, to comment on these cases, but of course, for sure, they have to be followed, and we will talk about them. The appeal against the decision of the General Court concerning the EIB and client Hearst. We've, I mean, talked about this one already several times, so it's progressing. Here, the issue was the financing by the EIB of a biomass power plant station in Galicia, I think, in Spain. And here, client Hearst was asking for internal review of that decision of one of the decision-making body of the EIB on the basis of the Aarhus regulation, Article 10, I think, or 12, 10, I think. And it's the question is whether that decision can be qualified as environmental law under the Aarhus Convention, and whether this decision had legally binding an external effect. And so the EIB, of course, is contesting that, and so the client Hearst, so EIB decided that the claim for internal review was inadmissible. And so client Hearst appealed, and the General Court sided with client Hearst, and so now we are at the level of the Court of Justice. So this one is, of course, interesting. The competition, the competition cases. So we see that we have a bit less state aid, but they are probably not all listed there. You mentioned, I think, the Covestro case. I guess this is the one you were referring to a bit earlier. So it's still under appeal. We have this, probably the end of this very old saga concerning DI, so on preferential tariffs in Greece. And so we still, of course, a few support schemes in different member states, but it's not all listed there. But it seemed to me that there was a little slowdown. We will see if that's indeed the case. On the competition front, more like antitrust and measure control, it has slowed down for a long time now. It's true. The Commission is not super active as it used to be in the early 2010 and 2000s. And so the BEH case, we had the hearing end of September. So this is about an exclusionary conduct regarding access to network in Bulgaria, Bulgarian energy. And there are these groups of decision of the Commission concerning the restructuring of the incumbents in Germany. And so there, of course, this is also progressing, but this is very big. So that's it. There are, of course, other cases. It's always a selection, but yeah, plenty to discuss next time. Thank you very much.
Thank you, Adrien. Thank you very much. We don't have a lot of time. I don't see one question in the chat. Oh, it's not a question, just a thank you from Vikram. Thank you, Vikram. But I don't know if there's one burning question that anyone would like to take at the moment. We must have then kept everybody on their toes so far then and explained everything. Well, as we've seen, there are always lots of interesting cases being handed down in these intervals that we discuss them. So a lot of new cases, a lot of new developments, although this Tempest case, I think, is being recalled in many of the procedural cases. The ACER cases, of course, are also very fascinating, lots of things going on there. And then we'll have the taxonomy, I think, which will also break new ground legally and be very important across the board. So I think it's time to round things up and wish everybody a great weekend. Thanks again to Adrien for participating, to my colleagues also in Florence for helping us host this seminar. And Max will produce a short summary for us, which will be posted on the website. And these webinars are always recorded. So if you get bored under the Christmas tree, then you can always find it on YouTube and spend your Christmas thinking about the taxonomy regulation and joyful events. So thank you again. And we'll see you back here next year at some point, I think, probably in the early summer for the next update. In the meantime, of course, there are many other activities going on at the Florence School. So thank you again. Thank you, Adrien, and thank you to the Florence School, and also, of course, to the Robert Schumann Center who hosts this for us now. Okay, thank you very much.
Bye-bye.
Bye-bye. Bye.